the alleged errors and things that happened during the trial, I believe that's not appropriate for the sentencing. While I do disagree heavily with most of what he said about those issues, I'm not going to address them independently. I do want to address some of the things that the defense said about what knowledge we have of the situation. So the defense kept saying the word independent evidence over and over and over, and that the court should look to the independent evidence of Douglas Benefield's behavior to support some of these downward departure reasons. However, I have arguments about some of those things that the defense said. For instance, the defense wants you to look at Doug Benefield's deposition testimony that was not allowed to come in to the trial. And we all know that there were reasons that was not allowed to come in the trial. It was following the rules of evidence. However, I can represent to the court that at least one of the things that Mr. Taylor said is completely inaccurate, that Doug Benefield, while he admitted to firing the gun, he never said he did it to intimidate her. So I would just ask that we be cautious about what we are presenting as fact when it is not necessarily fact. The defense also said that Doug Benefield violated the South Carolina injunction. That is also one thing that was never established definitively one way or another, whether he violated it. The defense said that Doug Benefield was caught by a neighbor spying into the house. There are differences of opinions as to that. And I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male, but if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having is bits and pieces of a rocky marriage that in the state's argument do not rise to prior acts of domestic violence. Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage. The victim, was never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate and blow things out of proportion. And that is the state's entire theory, is that this particular defendant just blows things out of proportion and makes things into something that never existed. So the court should consider that in trying to determine whether this victim somehow played into this whole incident that happened the night of the shooting. One of the other things that I will mention from what the defense was alleging was improper rulings by the court, I do want to say in isolation just this one thing. The DNA report, the defense was saying that it would have shown that Doug Benefield's DNA was on Ashley Benefield's arm. And I believe that's a false statement. It would have shown that there was some DNA on her that could have been Doug Benefield's DNA, but it also could have been a family member. And the child, that was a toddler at the time, was clearly a family member. So to imply that the DNA report would have clearly shown that Doug Benefield was holding her and at the time that this incident was going on, I believe is not an accurate statement. So as far as the defendant being a willing participant, the victim being a willing participant, we do only have Ashley Benefield's version of events for that night. That's all we have. And I know the defense in the motion or in the memorandum has mentioned that the court should take what she says as truth, that it's uncontroverted and unimpeached. But I have a case here, Judge, it's Early versus State, 223 Southern 3rd, 1023, which is a First District Court of Appeal case from 2017. And while this talks about a jury, it does give guidance as to the type of situation that we have here. Even when there is no other witness to the events besides the defendant, a jury is not required to accept the defendant's testimony in support of his self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. So I believe that the court can wholeheartedly believe what Ashley Benefield said on the stand, or the court is allowed to disbelieve everything she said on the stand. And if that is the basis for this downward departure request, that he was a willing participant or an instigator, the entire evidence that we have of that comes from Ashley Benefield herself. And the state argues that her credibility is below, much below where it should be, and that it is obvious this was a pattern of behavior, that she had a goal to raise this child by herself and to get Doug Benefield out of their lives, and this was the culmination of that pattern. And so her credibility is lower than it should be. The other downward departure reasons that the defense mentioned, the one was the PTSD. But if the court looks at that downward departure reason, it says that that the defendant has a mental disability or problem that requires specialized treatment. And the defense has put on nothing to say that she needs specialized treatment for this, even if the court accepts that she does have PTSD. So the defense has not satisfied their burden for that. As far as isolated, the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. I would argue that does not apply. Obviously, this was not a one-time thing. This was a pattern of conduct over a very long period of time. Additionally, it's not unsophisticated. It's a culmination of a pattern. And if the court looks at the facts that came out in trial, that there were multiple firearms placed around the house, the daughter and mother were out of the house conveniently at the time when all of this happened, and this defendant is the only one still alive that has the correct, what she's trying to say is the correct version of events. So I would argue that that downward departure reason does not apply, or the defense has not met their burden. And Judge, I think it's very difficult when this entire trial has been about pretty much demonizing Doug Benefield and making this defendant the victim, when in fact it was the opposite. Doug Benefield did nothing but try to love this woman and try to love this child and try to do the best by them, and at every turn she abused him, in my opinion. She tried to withhold this child. She tried to get him in trouble at every turn. She tried to do everything to undermine any relationship that they would have. And he continued to go back, which was probably his one fault, was that he continued to go back and he continued to think that he could make this work. And this defendant took advantage of that. And then when she can't get relief from anywhere else, shoots and kills him. And she got exactly what she wanted for a time. And for that, Judge, we would ask that you sentence her to the maximum 30 years.
Thank you. Rebuttal.
I'm good.
All right. Okay, so at this point, I've heard all the evidence. I've heard the arguments of counsel. Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard. Of course, there was a stack of letters that I got from your attorney as part of the downward departure. Heard Dr. Russell's testimony today, of course, presided over the entire trial. Heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent. All right. I also give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea, I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court won't interpret her choosing not to as a lack of indication of remorse.
Fair enough. And as I said, you're not required to at all. All right, is there any legal reason why sentence cannot be imposed?
No, sir.
All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2,